Out. Hi, everyone. Thank you so much for joining us. I'm Jennifer Burns. I'm head of the Business Insight Center at the Central Library. With us this evening is Jason Klimek of Barclay Damon, and he's going to be discussing some hot off the press news about all the regulations being null and void and what that exactly means. Put any questions into the chat, and Jason, take it away. Thanks for being with us.
Oh, thank you for having me, Jen. Yeah, that lawsuit, there's even more hot off the presses news, like literally 5-10 minutes ago at the most. So we'll start from the beginning. The lawsuit that we're referring to is the Leafly lawsuit, where Leafly, if you're not familiar, is kind of a third party, what do they call it? Like marketplace or aggregator, where you go onto their website, you can type in a dispensary name, or say like dispensaries near me, they'll populate a list, and in a lot of markets you can order right through them and they place the order with the dispensary, so on and so forth. So the regulations kind of more or less ban that practice, and the justification was this could be used for undue influence, meaning that they could steer customers to certain dispensaries that pay more money or something like that. So they wanted to avoid that entire undue influence. And so they got rid of it. So Leafly sued along with one of the dispensaries that wanted to sign with Leafly. There was an initial injunction that prevented OCM from enforcing those rules. And today there was a lawsuit that came, or the decision came down that purported to void all of the regulations. Because in the requested relief, they literally were like, we want these specific things voided. And it was like subparagraphs of sections in the regs. It was not the whole thing. But the judge's order came out and said, the following are voided, and it was literally like all of the regulations. And so this caught everybody off guard, because typically judges don't grant relief outside of the requested relief. And you would see something like this usually, like if there was going to be such a broad and sweeping thing where we're just going to wipe all the regulations off the map, it would usually be stayed pending appeal, meaning like the judge issues the order, but they put a pause on it saying, okay, go check me at the appellate court. I'm not going to throw everything into chaos until like somebody else kind of says this is okay. So it was kind of weird in those two ways. It was outside the scope of requested relief. There was no stay pending appeal. So when that was released earlier today, I had a lot of conversations, and it was like, it's got to be an error. It just doesn't make sense. And then just literally 5-10 minutes ago, they in fact the judge issued a corrected judgment order that just narrows it down to those requested things. So there are AU regulations. They are in place, and you can't violate them. So that's where we are right now. OCM might appeal it, or if you actually read through the decision, the judge didn't really get to the merits of it, because they had made like First Amendment claims. This is an impermissible restriction on free speech, so on and so forth. He didn't really get to those. He basically said, look, they violated the Administrative Procedures Act, which is like the driest stuff on earth. It's, well, they didn't respond to the public comment. They basically just said, we received comments and we didn't make a change. When under the APA, they're really supposed to say, like, we received these comments, and then they address the substantive issue in the comment, and then they can make a conclusion of, we didn't want to do that for this reason. And that was basically what the judge said is, hey, they didn't actually follow the rules in this regard, like the full, like putting this out as to why they were doing this. So if OCM could always appeal the decision, because there is a question of whether it does in fact rise to arbitrary and capricious, like the judge said. But what they could also do is if they really want that rule back, they can just amend the regulations, put the rules back in, and just follow the Administrative Procedures Act. If people object and they want to, keep the rule as is, the OCM can just respond and say, this is why we're doing it, and here's our reasoning. And that would presumably be okay under the judge's ruling. So we'll see what the OCM wants to do, whether they're just going to kind of let this one fly or not. But it does, with these companies coming in and being able to do that, it does pose an issue for some dispensaries because, and I'm just making up numbers, I have no idea what they actually charge. But let's say that, like, to appear at the top of the list, when somebody says dispensary near me, they want to charge you $20,000 a month. Like, I don't know. Totally throwing it out there. But, like, let's just say that was the case. Well, then there's only, a subset of dispensaries that could afford that, where most probably couldn't. And so that's kind of, like, in OCM's minds, allowing a third-party company to pick the winners and losers, and it's going to favor the moneyed parties. So that's what OCM is trying to prevent. And, assuming that they want to continue with that mindset, I would expect them to do something, make new rules or challenge this decision or something like that. So yeah, I mean, that's kind of what I'm thinking about this, but yeah, it's not, the sky is not falling. The rules are still in effect. It's not the end of the world, as almost every single one of my clients was calling me today thinking it was. So we're good.
Awesome. Okay, so let's move on to the lottery system, the queue. What is all this? What is going on with it?
So, all right, just a quick refresher on the lottery and the queue and everything like that. So there was 2 application periods, November 17th and December 18th. And so if you applied by 5 p.m. on November 17th or 5 p.m. by December 18th, that determined which queue you would fall into, the aptly named November or December queues. And what they did was, initially when the regs came out, when, we didn't really know what licensing looked like, we all kind of thought that it was going to be a substantive review of the license applications. Like, you'd have to submit a social equity plan, you'd have to do X, Y, and Z, and they would kind of like grade your application like they did in card, actually. But that's not what happened. What happened, it was essentially a lottery. When you submitted an application, you got 1 ticket to the lottery, with an exception. If you fell into extra priority, which means that you had an income less than 80% of the median income in your zip code, you had a cannabis conviction, or you were the dependent of somebody who had a cannabis conviction, and you came from a community that was disproportionately impacted by cannabis prohibition, if you had all 3 of those things, you got extra priority, which means you got 3 lottery tickets for your submission. Then when that happened, they put you into a queue, or they did a random lottery, and then based on your number, they put you into a queue. And that queue is solely to determine the order in which you are reviewed. That doesn't mean that that's the order they get licenses, because let's say that you have one person at number 1 in the queue, so they are in the top spot, and you have a person that's number 10 in the queue. Let's say that person in number 1 had a deficiency. They get contacted by the OCM and say, hey, we need you to fix XYZ. And those fixes required some time. You get 30 days to do it. So it requires some time. You take the 30 days, then OCM has to review everything, and maybe you're 30 days past that. Meanwhile, the guy at number 10 gets a deficiency notice, and it just says, oh, we just need you to check this box. So you go and check the box, you finish it in 30 seconds, goes back to OCM, they look at it and say, good to go. If you're number 10, you could actually get a license before number 1, because you cured your deficiencies like that and they were able to review it. Number 1 is still working on curing their deficiencies, and OCM has to review. So it doesn't determine the order in which you get a license. That being said, there were something along the lines of, when you in the November queue, if you separated out all of the micro businesses from the retail, there was something like 1,000 micro business applicants, and they were issuing roughly 250 licenses. So, if you were number 1,000 out of that, the odds of you getting a license were very low because basically 800 people would have to be removed from the queue before you would get that license. So, that's generally how it's been working, and so they've just been working their way through the queue, reviewing the licenses, and it is a relatively slow process because they got to review everything, and then they give you that 30-day window to cure deficiencies, and then once you cure the deficiencies, you can get granted your license, but that only happens at the monthly board meetings. So, I mean, I've had clients that cured their deficiencies, but it was like too close to the board meeting. It was like a day or two before, and they couldn't get into that board meeting to get the license. So they had to wait an entire other month to get the license because they were put on the list then. So, like, just how the whole process works is just time consuming. And now that they have the Office of General Services in there, OGS, streamlining things, they're not going to be streamlined at first. At first, they're going to look through everything. They're going to determine, the processes and things like that, and they're going to do everything by the book. So everything is just moving kind of slowly but methodically. And it does appear that the office is moving through and processing the applications for the cards, the conditional dispensaries, as well as the transitional applications for the conditional cultivators and conditional processors. So those ones seem to be moving a little bit quicker. We've seen more responses from the office on those as opposed to the general licensees, where I can say that I've had general licensees that were issued licenses in the first Cannabis Control Board meeting that issued general licenses back in February 27th, I think it was. And they paid their fees, they received the actual license certificate, and we haven't heard anything else. Like, it's been kind of radio silence on what the next steps are. What do we need to do for compliance? There are some things you can do. Like, there is a checklist for like cards that got, that cards received. So we've been using that for our dispensary clients because the regulations are the same, the requirements are the same. So that's one thing. But like for micro businesses, it's more difficult because that's cultivation, processing, distribution, and retail. And so we don't really have checklists for 3/4 of those. So that's kind of the overview of that. And then we're into the December queue now. They've actually started, some of my clients on the December queue have started getting deficiency notices. So we know that they're reviewing those applications. And I don't know if I would expect the next Cannabis Control Board meeting to probably be in 2 to 3 weeks. So hypothetically, if some of these clients from the December queue fix their deficiencies very quickly, they could be licensed in the April Cannabis Control Board meeting, but we'll just have to see how quickly the office can kind of move through them and put them on a list for licensing.
Kijana has a question. What if we never received an email regarding any deficiencies, but received a queue number? So does that mean they just haven't? I mean, is there any scenario where people don't have deficiencies?
So I have never seen it, nor have I heard. But it's hypothetically possible. Like you could have filled it out perfect. Usually there's like one little thing they want followed up on. But yeah, it's not impossible. But receiving a queue number just means that's the order in which they will review your application. I imagine once they hit their predetermined cap, which they had said was 250 for the November queue for the retail licenses and 110 for micro business licenses, I doubt they're going to continue reviewing, but I don't know how they're going to do that. And nobody knows where they are in the queue. Like literally the only reason I know about where they are in queues sometimes is because a client says to me, oh, I'm getting, I got this deficiency notice, and I look at their queue number and okay, that's where they are in the queue, but it's not public information. So it's pretty impossible to tell where they are unless somebody tells you that they're getting reviewed.
So question, so, you have 30 days to correct any deficiencies. If you do not get that in within 30 days, are you just completely out of the running?
Pretty
You're
much.
done.
The regs are pretty clear on that, that you have 30 days, and after that, your application will be voided. And I doubt that the office at this point is going to be very flexible on that because they have to be consistent. That's actually why they got sued in the Jenny's Baked at Home lawsuit that was filed like 2 or 3 weeks ago. The kind of thrust of that complaint was that they treated that licensee differently than other licensees, purportedly that they knew were breaking the rules but ignored, and they targeted the plaintiff in that lawsuit. So they are now being ultra careful and consistent on everything to make sure that they are, checking all the boxes, treating everybody the same. So there's not, I don't think, going to be that flexibility that was kind of previous where they would say, okay, we'll work with you, blah, blah, blah. I think now this is what the regs say, no special favors.
When do you think there's gonna be, like, indoor cultivation licenses awarded?
So there there's two ways right now. One is there's the micro businesses, which have the option to do indoor if they chose it. They could do 3,500 square feet indoor, or 5,000 mixed light, or 10,000 outdoor, or there's a combination that I can't remember the numbers off the top of my head. So a few of those have been issued. Like, by far and away, there's been more dispensary license issued, but a few micro businesses have been issued. There's a few actually in and around Monroe County, Ontario County. And then there's in the December queue, there are people who applied for tier 1 and tier 2 indoor cultivation licenses. So tier 1 is up to 5,000 square feet, and tier 2 is up to 12,500 square feet. And so there were 20 of each of those licenses. And so when they do those when they get to those licensees and they select them and they select the total of 40, there will be indoor grows happening, but it will also be somewhat delayed. I mean, let's say that they issue some of those licenses in April in the next few weeks. By the time you do all the compliance stuff, when they actually get back to you, inspect you, give you authorization, you got to figure that's assuming that you already have a built out area. Like, if you have to build out, then you're talking months down the road. But let's assume that you have a built out location and literally all you have to do is wait for compliance to give you the thumbs up. That's probably going to take at least a month, maybe two. And then you have to grow, harvest, dry, trim, blah, blah, blah. I mean, maybe we would expect to see general licensees growing indoor flower and selling it at market maybe by the fall, at the earliest, maybe more towards winter, just because of the timelines of everything. So they will be coming online. There is indoor flower right now from all the medical companies who got their adult use licenses. They are allowed to sell, and they have up to 100,000 square foot grows. So they are right now the only suppliers of indoor flower on the market. There's some of the conditional cultivators have greenhouses, and then there's just a lot of outdoor as well.
So is everyone in the same queue? Like, is there a separate queue for dispensary, micro business, or is it just all one queue
So
for everybody?
unfortunately for the November queue, they put together micro and retail. So it was really a pain to figure out, if you were a retail licensee, where you actually fell in the queue. Like, you had to separate out the micro, you had to get rid of the duplicates and things like that. But for the November queue, they separated out a lot of things. So there's like a dispensary queue, a processing queue, a distribution queue, and a cultivation queue. And then they also just recently released, and it was really nice that they did, the processing queue with the types of processing licenses. So one of the issues was there are three types of processing licenses. The type 1, which is, well, let's start at the bottom. The type 3 is branding and packaging. So that's like the lowest level. The type 2 is the type 3 plus manufacturing, blending, and infusion. So basically, you're taking distillate that you bought from somebody and you're making gummies, that kind of thing. Then the type 1 is the type 2 and 3 licenses plus extraction. So they were issuing 55 type 1, 100 type 2, and unlimited type 3, because like if you want to exist as a brand, I always pick on Cookies because everybody knows Cookies and they're the biggest brand. If Cookies wants to come into New York and they just want to exist as a brand, they don't want to get a cultivation or processing license, they just want to license their intellectual property, their brand, to a company, they pick up a type 3 license. So that's why they were unlimited. So when they first announced the processor queue, it was really difficult to tell if you were going to get a license or not, because there were so many type 3 licenses that were unlimited. It made the queue kind of almost pointless to try to figure out if you knew if you were going to get a license, because you could have had all type 3s in front of you hypothetically, and so you would get one of the 55 type 1s, for example. They just recently re-released the queue with each license license type. So type 1, type 2, type 3. So now you can see how many, if you're going for a type 1, how many type 1s are in front of you. And if there's less than 55, you're probably going to get a type 1. So that has been helpful. But yeah, so now they've started separating them out, but the November queue, they were all just kind of mashed together, which also meant, despite the fact that there was a different number of retail and micro business licenses, you were all just reviewed in that order. So, you were being reviewed in this with micro businesses and things like that. And so that kind of slowed things down, I think, a little bit too, instead of working at parallel paths. But I think with the December queue, that's not going to be the case.
So question, is there a website or a link where people can see the lists of the different queues?
Yep, I'll throw it in the chat. Give me 2 seconds. So if you go here and you scroll down like a little bit, you'll see the December queues, and there's also a link for the November queue.
So hypothetically, are they done looking at the November queue?
I have no idea. Like,
Okay.
they haven't said anything. I don't know where they are. You would think that they would. Well, they're not. My guess is they're not going to say anything until they issue the total number of licenses they wanted to out of the November queue. So, and I think if you like counted up how many dispensary and micro business licenses they've issued, it's nowhere near the 250 dispensary and 110 micro. So, and the micro one too is a little confusing because the conditional cultivators can transition into a micro business, and many have, and that does not count against the 110 for the November queue. So to the extent that like any of the micro businesses listed on the November queue have received a license already, but they were transitioning from a conditional cultivator to the micro, they don't count against that 110. It's only the people who applied in the general applicant pool that count against the 110. So even with the micros, it's hard to tell how many licenses they've issued versus how many are left.
So if you got a processing license, do you have to start processing within a year? Like with the dispensary, you have to be open within a year?
The rules do say like you have to be up and running within 12 months. I don't know how much they are. I don't know how strict they're going to be on it. Like, I can tell you that with the processing, you need to be GMP, good manufacturing processes. you need to do that within 12 months, and the regulations do read that you can kind of start operations and then just get that certification within 12 months. So hypothetically, you should be able to get up and running within that 12 months. And then you can get like GMP if you're doing processing or anything like that. But they do want to see forward progress. One of the big things that it's applicable for is proximity protection. So if you're a dispensary or a micro business that's doing retail, you get proximity protection when your location is approved, which means like nobody can come within 1,000 feet or 2,000 feet, depending on the population. But in order to keep that proximity protection, after 20 days, you have to show the office that you have been moving forward with that location, whether it's, you've signed the final lease, you started build out, whatever it is, you have to do that in order to keep that proximity protection. If you don't, they will. It's not even they can. In their guidance, it says they will revoke it. So it's important to keep that forward momentum.
Yeah, I'm just thinking of people that like I've met with some people that wanted to get a processing license and they really don't know how to process. So like, you know, I guess terms of like you're saying like you're getting ramped up. So if you have like the added burden of like, oh, I guess I better learn how to start processing now because I've got this license.
Yeah, I mean, but in that circumstance, there's certainly consultants that can help, or I mean, you can flip a license too. I have definitely seen people turn around and sell licenses for enough money that I questioned why I didn't apply for a license. like, um, really messed that one up. My whatever. Um, so yes, I mean that's an option too. Like you can
Mhm,
totally sell the license. Technically, you can't transfer a license, but there's ways to transfer the ownership in the company to blah blah blah. That essentially ends up being transfer a license. So always an option too, because the limited licensing means those licenses are valuable.
mhm. And so we have a question about, are all the card applications dead in the water? What's going on with that?
No, so they are. So the cards are moving forward. So what was it? The injunction was lifted December 4th. If you had put in your location survey prior to the injunction going in, which was August 7th, and you received proximity protection, what you had to do is you had to keep that proximity protection, you had to complete your post selection application by December 18th at 5 p.m. If you did that, then you just continue to move through the program. Like we have one of the card dispensaries, I think might actually be opening this weekend in Rochester, right on Monroe Ave. I'm not 100% sure it's this weekend, but if it's not, it's very soon. Um, and so people like that submitted and are moving forward. If you didn't have location protection, which was definitely a number of a lot of cards, you needed to just submit the post selection application at some point. The sooner the better. There was no like absolute deadline. The deadline was only if you had proximity protection and wanted to keep it. So now, if you're a card and let's say you're finding your location, once you get that signed lease, you can complete your post selection application, submit that signed lease, then the office will start to review that, see if it's compliant, issue you proximity protection, and then if you get that, you get a card welcome packet that basically says, okay, great, here's the next steps, here's a checklist of everything we need. When you get all that stuff, submit it to us, and then we will schedule a virtual interview, which is literally virtual. You take your phone or your laptop and you walk it around your store for anywhere between 15 minutes to an hour. And then if you're good to go, they'll tell you to pick an opening date. They'll tell you that you can now start receiving inventory, and then you're good to go. So they are absolutely doing it. The cards are still moving forward. Um, yeah, that's still a viable license.
So are there any lawsuits that have yet to be settled?
Well, the Jenny's baked at home one, that's the challenging the processes. But that's not really challenging the OCM so much. It's basically like they told that company everything you have is under quarantine because you were using an unauthorized method of extraction. So like that's one, but it's not kind of like what I would call an existential threat to
Mhm.
the industry. There is one that is actually concerning, and it was, I don't know if you saw this one. It's called like Valencia AG, I think it is. And like it was when you first read the first draft, not draft, but like the first complaint, it has since been pulled back and amended. And I'll talk about that in a second. But when you first read the complaint, it was kind of jaw dropping because some of the language they used, you're like, oh my God, an attorney attached their name to this. They were like literally talking about like the pigmentation of people's skin on the cannabis control board. Yeah, it's wild. Like everybody I everybody I talked to about it, like our jaws hit the floor. Like I cannot believe an attorney put this in writing. Um, but that one, it was pulled back, and what are they called? Like the Pacific Legal Foundation or something along those lines. They are like this libertarian legal group that challenges laws, typically like affirmative action type laws. That's what they're doing here. Um, and they actually have they're very well funded, and they actually have a huge success rate at the Supreme Court of the United States. Like 17 out of 20 lawsuits they've won at the Supreme Court. And so they picked up this complaint, and the language completely changed. Where, like, as before, you were like, oh my God, this is ridiculous, to oh my God, this is serious. Like they were using Supreme Court language, they are tracking things. This is a case that is destined to this for the Supreme Court unless another one like that is similar challenging these types of things gets there first. So it's that one is hypothetically an existential threat because they are challenging the social equity provisions of the MRTA, which is kind of foundational. So that one has yet to, really progress. They're still in the very early stages of litigation in the Northern District, which is like Syracuse, Albany area. Um, and yeah, I think that's one of the bigger ones that is out there. There's one that's also challenging the cannabinoid hemp regulations that regulate now the amount of THC that can be in cannabinoid hemp products, where they put in a ratio of like you can have 15 parts non THC to 1 part THC. And basically, they're trying to eliminate intoxicating hemp products from the market and just point you to adult use instead. So that's one that's hanging out there. And those are the ones that I can think of off the top of my head that are still out there. Most of them are either very, very new or not any real threat. Oh, actually, I say that, just remembered. There's one called Gracious Greens. This one is kind of an existential threat to cards specifically. Gracious Greens lawsuit is filed. I can't remember where it's filed actually, but it's challenging the 1,000-foot buffer between dispensaries. And the issue why that's such a big deal is because with card, particularly, they wanted to give elbow room. They didn't want people piling in. They wanted to give these social equity businesses a chance to succeed. If that 1,000-foot buffer goes away, that means that the biggest money parties could set up right next to your shop. And, having worked with a lot of cards, you know, typically these are people who have been disproportionately impacted by cannabis prohibition. They are not multimillionaires that can come in and spend unlimited funds. But with a general license, with no buffer, people can do just that, and they can set up shop right next to you and just knock you right out of business. So that lawsuit is to a potential big issue. However, I did discuss it with some attorneys, and we all kind of think that it's a pretty weak lawsuit. We don't even think the plaintiffs necessarily have standing to sue. So we'll see where that goes. That was just recently filed, maybe a week and a half, 2 weeks ago. It hasn't really gone anywhere yet. So that's the other one.
Do liquor stores have that 1,000-foot rule?
Technically, they have a rule where it's like you can't have more than three liquor licenses within a 500-foot radius, I believe it is. But they can wait, and the cannabis regulations took this language right out of the liquor law, is they can waive that rule for the public convenience and advantage. Basically, they look and say, okay, how many liquor stores will serve a typical population size? How big is the population? Can we justify putting that many liquor licenses together? But I mean, in Rochester, you go down to Monroe Ave and you see bar, 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 bar. Like, they
Yeah.
typically, with like that kind of stuff, they don't really care that much anymore. And they'll waive the rule a lot. And technically, the Cannabis Control Board does have the ability for the public convenience and advantage to waive that 1,000-foot buffer, but they really, I don't think, want to do that until they give the cards a chance to really stand up. With the first Vericite lawsuit that enjoined the Finger Lakes and the 4 other regions, the Fiore lawsuit, they're like, look, these guys have had it pretty hard. Let's give them the market for, I don't know, maybe a year or two without like getting enjoined, and then we can see. So yeah, that's the issue there.
So question, if we applied for card and the adult use dispensary in November with a location, do we get priority or will we have to fill out the post form you were just speaking of?
So OCM would have made you probably, or they would have sent you an email saying, hey, we know that you're both in card and the general, assuming that you like checked the box that you have an interest in the card license or another license. And you need to pick one. And if you don't pick, they automatically void out your general one and just give you the card one. So to the extent that that's relevant, that's how that goes. There do seem to be some exceptions to that. Like if you were a minority owner in a card, like you owned 20% of it or something like that, and you applied in the general, then that might not apply to you and you can go forward both on the card license and the general license. And if you were in that case, you would, with the card license, you would still fill out the post-selection application to move forward. And on the general, you would just wait for them to give you a deficiency notice, fix the deficiencies, and then get licensed in a Cannabis Control Board meeting.
What's the duration? So the card license was good for like what, 3 years?
4 years.
4 years? And then the regular adult
2
use.
years.
Okay. So it is more advantageous to take the card if you can get the card.
It is, and there's other pros and cons with card. Like card is very strict in what you can do. So like for example, the justice involved person has to maintain 51% control. They have to have sole control, and they have to receive 51% of the profits. So like
Sorry, bear with us. Jason, you're frozen. If you can hear me. Nope. Jason. Okay. Let's give him a minute. And I think he's just gonna log back in, hopefully. So if you want to just give us 1 minute, sorry guys. Technology is a wonderful thing.
Hi, Jen. Jason just said his internet died. He's restarting it now. Sorry about that.
Sorry, technology.
Yeah, that's okay.
Uh,
Um, where were we?
I do not remember. I was
Um,
talking. Was it
okay.
card?
Card. The pros and cons of card versus regular.
Um.
So
Oh,
cards 4 years, regulars two
yes,
years.
yes. So if there's like, let's say 3 owners, and in a general license, let's say one's a woman, two are men, the woman has to own 51% to be a social equity licensee. But you can split the profits a third, a third, a third, so that everybody can get an equal amount. In card, you can't do that. If you're a 51% owner, you're only ever going to get 51% of the profits. Um, you also get like sole control. There's a lot of advantages, but there's a lot of disadvantages insofar as you can't sell the license for 4 years. If you are the justice involved person in card, then you are locked to that license. You can't sell it until you transition into a full license. That does make investment a little more difficult, but it's doable. We actually do have a lot of cards that have investments or have, you know, are looking at how to sell the license. You can sell like 49% now and then 51% in the future, things like that. So there are pros and cons to each license type. The generals are, much more transferable. Literally, you can get it and flip it the next day. But the cards, you're going to be part of it for 4 years.
If you have if you're a social equity applicant and you go to sell your license, do you have to sell it to another social equity applicant?
If it's within the first 3 years, I think is what the statute says. then you have to sell it to another social equity applicant. After 3 years, you do not.
So during those 3 years, do you have to get approval from OCM to sell it?
Yeah, any type of transfer or change in control. So change in control means like your board of directors, your manager, that changes, or somebody takes over 51%. So anytime that happens, or you want to transfer the entire entity, you need to not only get approval from OCM, you need to go then in front of the Cannabis Control Board, and basically it's like getting a license again. They have to kind of reapprove it. So it's a long process. Like we're doing that with some clients now, and the estimate is maybe this is going to take like 6 months. Like we just don't know because they don't have an official process for, okay, you want to transfer your license. Yeah, so we don't really know what the actual mechanics of it are, but yeah, it can be done, but you will have to have all the approvals.
Okay. Um, any, do they still have the chief equity officer or has he moved on?
So he is still, to my knowledge, on administrative leave. I don't know what that necessarily entails for the future. A lot of it, administrative leave is relatively common when, like, he was a major target in that lawsuit from Jenny's Baked at Home, and it was alleged that he said some improper things, perhaps, and so they just put him on administrative leave. It's no different than if somebody alleges or there was like an officer involved shooting. While they're investigating it, they're going to put him on administrative leave and go with that. So like that's where we are right now. Where that ultimately ends up, I don't know. But from what I've heard, that's where it is and hasn't changed.
Okay. Any other questions for Jason?
Yes, hi, Jen and Jason. This is Jonathan Rogers from Karen Rogers' husband. Nice to see you again. It's been a while. Um, we, me, my wife, and my daughter started with cards, and she was the victim. Um, our status is now we started with cards. Military had a situation, went to law, they had a lawsuit. So we kept waiting. They said, well, you guys go ahead and forget about cards, reapply. You reapply, $1,000. Since you're a card member, you'll be up top. So we did that. Get back, fix a few paperwork. Okay, you got a building. Yeah, we have a building. Does it meet the requirements? Yeah, meet the requirements. Okay, now we get a number, 700 and something number on a list of a bunch of names and businesses. And now we're waiting. But what are we waiting for now? A card license, the second license we applied for.
Well, if your card license is still valid, then you need to, if you haven't already, submit the post-selection application because that'll move your card license forward.
So the post, I believe we have what was that name again? The post?
Post-selection application, like you go into the New York Business Express portal, sign in, and it will say, like, usually right at the top, like card post-selection application, and then you start filling that out.
Okay, my
Did
wife.
they would they have sent you an email saying that you need to do that?
Maybe they're not the best at communication. So like I
Okay.
think initially around maybe December 7th, they sent people an email saying, hey, the injunction's lifted. If you already had a location, make sure you do this, blah, blah, blah. Like, so I mean, I would check back around December to see if you have any emails saying how to move forward. But if your card license is still valid, then you should just be able to go into the New York Business Express portal and fill out the post-selection application.
Okay. Okay, if our queue number is 1037, we probably won't get reviewed for a license.
I mean, I can't say for certain, but it is certainly a high number, and the odds of there being not 250 people who get dispensary licenses in front of you is relatively low. But again, for the card side of things, same thing. Go into the New York Business Express portal, and you should, when you go to like my dashboard, you should be able to see card post selection application. If you were granted a card license, like in Rochester, it was tough. It was, I forget when that was. Like, it was supposed to happen in December, like October, November of 22. Yeah. And then we got the injunction here, and then that lifted in like May of 23. And then there was like a May, June, July 3-month window where they were issuing some card licenses. And then by August, there was the injunction again. So if you're in the Finger Lakes and you got issued a card license probably within that May, June, July period, then you have an actual card license and you can do the post-selection application.
You guys didn't get a license. I think that's where the confusion is. They didn't get a license.
Got a number. I mean, 700.
But that's from the regular one. Oh yeah, I mean, you got a number, but you guys hadn't yet been awarded a card license.
No, we haven't. Because
No.
our license we're done with, and this new application here was going to be the new thing. That's what our assumption was.
Yeah, if
Yes.
you haven't gotten issued a card license, then like realistically, that in that May, June, July period, then you were just in the general and you fall into the queue where you fall in. The lower the number, the better. The higher the number, the less likely. Just because they were only issuing 250 dispensary licenses, so that's part of the issue. If you haven't heard from OCM, you just wait and see if you get a deficiency email. That's how you know they're looking at your application.
Okay. Deficiency email.
Yeah, it'll literally say, like, it'll come from OCM and it'll say, like, your application is deficient, and then it'll have a bunch of stuff like, you have 30 days, here are the deficiencies, please fix these.
We've done that a few times already.
Oh, really?
I think that was for the card license, though.
License? Okay.
Yeah, I'm pretty sure that was for the card license. It wasn't for the one you did in the fall, winter.
I know you've been working with Karen a lot, so she's not here right now. So, but yeah, I know you worked with her.
Yeah, so I think all of those deficiencies were for the card license, and you haven't received any deficiency notices for the new application.
Okay, so this is the number that we got from this list. Is that from the new application?
The 1,037?
Yes.
Yeah. That's
Okay.
for the new one.
Yeah.
I thought I saw a big number get their license in that last choice. I saw a high number.
Well, you have to look at the queue number, not the application number. So, like, on the left side of the list, that was like, you'll see like OCM, RETL 2023, and then 6 digits. That's just the application number. That's like literally when you hit submit on the application, then they just numbered you. The number on the right-hand side is your queue number, where you fell in the queue. So the higher the right-hand side number, the lower, higher, the worse off you are on the queue. I don't ever know if it's higher or lower.
Oh, okay. Now she's saying it's 708. 708. Okay.
708, I mean, it's hypothetically possible, but I just don't know. I mean, like, it's easy to say if you were within the top 100, yeah, you're probably going to get a license because there's 250 licensees. But when you start getting higher, then you start talking about, is there somebody who can come off or gets a deficiency and doesn't fill it out, doesn't correct it within 30 days? Is there were there micro businesses that were AUCCs that transitioned and so they don't count towards anything? Can you pull out a bunch of the micro businesses ahead of you? Like, you have to start like really thinking about that list. And then, it's hard to say. Like, it's kind of impossible if you're above, call it 3 or 400. At that point, it almost just becomes like you do have to wait.
Yeah.
So as numbers go, numbers, the next numbers replace, correct? So they had 250 last month, so 250 went out. So now from 1 to 250, now it's 251 to 400 will be the next. So
They're only issuing 250, give or take, licenses.
a month or a year or what?
No, like from the November queue. That's it. And then they're going to do another 250 from the December queue. After that, who knows? They have said that would, if they do 250 from the November, 250 from the December, and then call it like another, there's like a total of maybe 500 card licenses, give or take. That would be 1,000 dispensaries. They've said that they want a total of somewhere around 3,000, 3,500, like the same number of liquor stores they want as dispensaries, but they're not going to necessarily be doing that like soon. I don't know when they're going to do that. Who knows? I wouldn't expect it this year, certainly, but next year, the year after, potentially. But yeah, I think they're going to issue the rest of the card licenses plus the, call it 500-ish from the general.
So really, they're not picking from 1 to 250 like that. They're picking 250 numbers from your queue numbers, no matter where high or low they're at. Correct?
No, they're going in order of the queue. So like, if let's say that this is not the case, but let's say the first 250 people on the queue were all retail, not micro, and they all got their deficiencies in time, they all did everything, and then those 250 would be the 250 who get the licenses. If one of them missed their deficiency, then number 251 would get the license. Things like that. So like they're just taking the first 250 that meet all the qualifications, but they're going in the order of the queue.
Okay.
Jen, did you say something here on mute?
Hey, Jonna, what do you mean by consumer license?
Is it on-site consumption?
Maybe consumption. Yeah.
Yes. Who knows? They're not really like, if you look in the regs, those aren't even part of the regs. They have what's called, they kind of sidestep the issue, and they allow dispensaries to do what's called limited on-site consumption facility, which is like their kind of answer to the on-site consumption license, where a dispensary can have that, but they can't like sell products in there. What you would do is like, think of it like a liquor store, but with a place that you could drink, like not a bar, but like you would go buy your liquor and then go to a separate area, whether it's like outside or another room or something like that, and you would hang out there and drink. That's kind of what it would be like. So that's the closest thing right now. I mean, they do technically have the ability to issue on-site consumption licenses, but there's no word on them actually doing that anytime soon, and they would actually have to issue regulations on it because they only have regulations on the limited consumption facility, which has some different quirks than what the on-site consumption license would allow.
For edibles, you would need a processor license, correct?
Correct. If you wanted to make edibles, like you wanted to buy distillate and then make an edible with that, you would just need a type 2 processing license. If you wanted to extract the cannabis to make the distillate to then add, you would need a type 1 license. The queue closed for that in December. We have no idea when they will reopen that. They're going to issue 55 type 1, 100 type 2, and there's already 40 conditional processors out there. So there's, call it like a universe of like 200 processors. Plus then the micro businesses too can technically process as well. They can process their own stuff. So that would add an additional like sort of 220 micro businesses. So yeah, you would need a processing license.
Okay, last call for questions. Last call. Okay, Jason, thank you so much for your time. And thanks everybody for joining us. And this will be at our YouTube channel. So if you want to watch it again, because it was a lot of information, you can do that. Anyway, thanks so much and have a good rest of your evening. I see it's starting to snow. So yay.
Good old Rochester weather.
Good old Rochester. All right. Thanks everyone. Take care.
Bye.